Welcome once again to Lehto's Law. Here's Steve Lehto.
Ross is an attorney who keeps sending me good stories, and he's the one who sent me the story a while back about the RV, where somebody bought an RV, and because of some language in the documents at the time of purchase, they were forced to bring their lawsuit in Indiana, despite the fact they bought it in another state. And then it just became a mess because all this language that got hidden in the documents. And so he sent me an update of sorts on this type of case, and it involves a buyer faced with an arbitration agreement that was in the documents at the time of their purchase. And the question is, if somebody goes, I didn't see that, I didn't agree to that, and the other side says, yeah, but it's there. Courts routinely say, well, it's there, we're going to enforce it. Here, a court has said they're going to let the jury decide. And of course, if a jury is going to decide, that means this case is going to a jury. Headline from Virginia Lawyers Weekly is jury to decide if buyer agreed to arbitration, where a woman suing a manufacturer for its allegedly defective recreational vehicle alleged that she was not provided copies of a warranty containing the arbitration provision, was aware there was a warranty but was not aware of its contents, including the arbitration provision, and would not have signed the agreement if she was aware of it. A jury will decide if she agreed to the arbitration provisions. That's the issue. They're saying the arbitration provisions in the warranty. She's saying, I never saw the warranty until after I bought the vehicle. I knew it had a warranty, but that's simply because, you ask, does this thing have a warranty? Yes. What kind? 3 years, 36,000 miles. Okay. They don't say 3 years, 36,000 miles with an arbitration provision. So the matter is before the court on the defendant's motion to compel arbitration and a motion to dismiss. So she filed a lawsuit, and the defendants are saying, look, throw it out because she agreed to arbitrate. And so they are seeking to compel arbitration pursuant to the warranty, which mandates that she resolve her claims before the American Arbitration Association. They also move to dismiss the complaint pursuant to Civil Rules of Procedure 12b-3, the Federal Arbitration Act, and the Virginia Uniform Arbitration Act. So both of those statutes are there, and they say that the courts will favor arbitration when it's in place over litigation. And so the manufacturer argues that plaintiff signed the warranty acknowledgement indicating that she understood the written warranties and the warranties were provided to her. The signed warranty acknowledgement also stated that she has read and understood the warranties or has chosen not to read them. And I've mentioned before that if you sign a document, the courts will often look at that and go, well, you signed it, which means you read it, you understood it, and you agreed to its contents. Now, there are situations that might not be the case, but we also know that at the time you buy a vehicle, there's often a pile of documents you sign. And if you stop to read every word on every one of them, you'd still be there today. And I don't care when you started. It's not physically possible to read all those documents. So they often put language, not obviously in the first few pages of the documents, but they put it later in the documents. So plaintiff signed a separate checklist form indicating that the dealer satisfactorily performed the items on the orientation checklist, which included a review of the warranty and the contents of the owner's information package. Now, here's the interesting point. If they wanted to, they could put on that checklist, arbitration explained to customer. But they know if they put that there, it doesn't scare off buyers. So they say, okay, we explain the warranty and all its contents to the buyer. Sign there. On the other hand, plaintiff provides a sworn declaration stating that she was not provided copies of the warranty containing the arbitration provision when she signed that form. Her sworn declaration also asserts that she was aware there was a warranty, but was not aware of its contents or the arbitration process. She further swears that if she had known of the arbitration agreement, she would not have agreed to it. Okay, so that's her position. Based on these dueling contentions, a reasonable fact finder could find that the plaintiff did not enter into the arbitration agreement because she was not provided a copy of the warranty and therefore was unaware of its existence. The court found that a material dispute of genuine fact exists as to whether plaintiff was provided the warranty at the time she signed the warranty, the warranty acknowledgement form. This dispute is material to these proceedings because it concerns plaintiff's assent to the arbitration agreement. Thus, this court is required to hold a jury trial on whether plaintiff was provided the warranty at the time she signed the form and whether she was aware of the arbitration provision or should have been aware of it. Accordingly, the court will set the matter for a jury trial on this limited issue. So this is a trial court ruling, and it's made the Lawyers Weekly in Virginia because it is so noteworthy. And this is a fascinating concept. Now, this is the kind of thing that a lot of people don't know about and will find confusing, and I apologize, but I'll try to explain this. And I've mentioned this concept before, that when you go into a courtroom that's in a trial setting, there is a jury and a judge. There's all kinds of other people in it too, but for the purpose of the discussion, think of the judge and the jury. The judge decides issues of law. The jury decides issues of fact. Now, if you've decided to have a bench trial where the judge decides everything, great, you can do that too. However, to get to a jury, there must be questions of fact. So what happens in a lot of cases is the defendants will come forward and say, Your Honor, there's really nothing to try here. There's nothing to put before the jury. And here's why. The plaintiff has either admitted key facts or the plaintiff cannot prove something they're trying to prove, and so on. And so there's situations where a court will say there's nothing to put to a jury here because of the situation. Therefore, we're not going to have a jury trial. The court will simply rule on what's before it because it can. That does happen. So you're always looking for questions of fact for the jury. And so what the court here is saying is the defendants are saying, look, there's a warranty that contains a warranty provision that has an arbitration clause, and she's signed documents that she understood the warranty, she's read the warranty, whatever. And so therefore, she's agreed to arbitrate. This case must be dismissed. There's nothing to try. And she is saying, I did not see those documents. No one explained them to me. I knew there was a warranty, but I didn't know the terms or any of the provisions in it that would have required me to arbitrate. And I've seen courts faced with this exact question who've said, it's in the document, you signed a document, there you go. You agreed to arbitrate, get out of my courtroom. And the interesting thing here is the judge is saying, well, wait a second. You say it's in the documents, and she saw those documents. She's saying she never saw the documents. Therefore, we have a fact question. That is a factual question. So I suspect what's going to happen is outside of the presence of the jury, the judge is going to tell the parties, we have a threshold question here. Did she or did she not see the arbitration agreement? Because if she did, it's like, stop, you're out of here. If she did not, then it's, proceed and we continue. So I suspect what they're going to do is bring the jury back in and say, or start with a jury and say, there is a question that needs to be decided by the jury. And the question is going to involve this arbitration agreement. And the plaintiff would put in all the evidence regarding that arbitration agreement, whether she saw it, whether she knew what it meant, any of that stuff. The defense can cross-examine her, and the defense can put in their witnesses on that issue. And the jury will be sent back and told, you have to answer this one question. Should the plaintiff be held to that arbitration agreement? Yes or no? If yes, they come back, rule, boom, she's off to arbitration. If they come back and they say, no, she can proceed, then she gets to proceed. So I'm not aware that I've ever seen a case in a consumer setting where somebody's actually gotten the right to have a jury decide whether or not they should be forced to arbitrate. Attorneys who spend a lot of time in court will tell you that if you watch court proceedings, you will see a propensity of judges to dismiss cases when they can, meaning that it appears sometimes that even if it's borderline, they'll just dismiss the case to get the case off their docket, as they say. And so when faced with the proposition that you can have a full-blown jury trial on this, or you can tell them to go arbitrate where someone else will take care of it, a lot of judges go, go arbitrate. Go arbitrate. And there's no way to prove that that's the case. I just think that that's something I've observed, and I know other attorneys who've commented on that. So I'm fascinated by this, that a judge actually said, well, you know something? She says she didn't see it. You say she did. It's a fact question. Let's let a jury decide. So I'm fascinated by this. It's not an appellate court case or a Supreme Court case, and this is not going to be binding on anybody necessarily except for these parties unless it goes up higher, and we'll see what happens then, because what could happen here is a jury could find in her favor. The jury could then award her damages on the defective RV, and then, of course, the manufacturer could appeal it and say, we had an arbitration provision all along, that trial was wrong. We'll see what happens. But Ross, thanks for sending this. I think you're 5 for 5 now in stories you've sent me. From Virginia Lawyers Weekly, jury to decide if buyer agreed to arbitration in an RV case. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. In life, it's not where you go, it's who you travel with.